The first skirmish was held in the ongoing online war between Jonathan Frauditor Troll Huneault and Christopher Denver Metro Audits Cordova, represented by Stephen C. Vondran and that Randall S., the Unhinged Attorney Newman, Esquire, respectfully, and was held on Monday as Vondran filed a motion to dismiss the ongoing federal lawsuit. That motion to dismiss got off to a troubling start, as it initially only covered Huneault and not his wife, co-defendant Nneka Ohiri. Attorney Newman pounced on this, filing a motion to hold Ohiri in default almost immediately after Vondran's initial filing. According to Huneault in a live stream held later in the day, Newman had agreed to withdraw the motion for default after Vondran filed an updated motion to dismiss, but had yet to do so as of press time. As is, the new motion calls for a hearing on November 18th, 2025, in the United States District Court for the Northern District of California to hear the motion to dismiss the complaint. The complaint is seeking a complete dismissal of the claims against Huneault and Ohiri, based on the grounds that Newman failed to state a claim upon which relief can be granted. Vondran is seeking attorney's fees and reimbursement of the costs that Huneault incurred defending himself in the case. As Huneault made clear in his live stream Wednesday night, this is just the first skirmish in a longer war. According to Huneault, Newman is set to file an amended complaint in the near future as a response to the motion to dismiss, which will result in a second motion to dismiss. Key takeaways to follow from Wednesday's filing include the fact that even in the corrected version of the filing, Ohiri is barely mentioned. This is troubling, as Ohiri, not Huneault, took full responsibility for the channel in the DMCA counterclaim. While there are statements in defense of Huneault, the filing seems to set up a scenario where the case against Huneault could be dropped, leaving Ohiri on the hook for the rest of the lawsuit. While it contains some iffy logic, relying heavily on a parody defense to excuse the use of Cordova's material, for example, the key takeaway from the document is their strong statement that Huneault's videos did not cause financial damage to Cordova or a viable market replacement for Cordova's works. Putting aside the amateurish market research done by Huneault over the weekend polling of his audience, included as an exhibit in the filing, Cordova and Newman may face challenges in establishing a monetary value of the damages they're seeking. It's hard to see a scenario where damages awarded to Cordova could total more than the tens of thousands of dollars. More interesting is the context of the lawsuit in the world where it is playing out. Both sides see themselves as the hero of the story. Cordova portrays himself as a copyright holder who is defending his work against the reuse for profit by someone who has attempted to establish a market substitute for the original product. Huneault has billed himself, with Ohiri, a minor player in the saga, as a man of the people, an all-American type, despite Huneault being Canadian, who is standing up for the little guy who wants to poke fun at the established copyright creator without being sued into oblivion. Both sides have real points and real issues that the creators of the DMCA never fully decided how to handle, relying on a vague fair use idea which is not codified into law to handle disputes. There also seems to be established guidelines on YouTube that protect works from major corporations from the use of copyrighted material. Play more than a few seconds of an Eagles song, for example, and feel the wrath of Don Henley and his record label in court. Sing a parody of a popular song on a live stream and watch as your monetization is suddenly shared, with multiple entities claiming legal rights over your work as its derivative content from the original work. YouTube does not offer the same protections to smaller content creators on either side and has made its dispute policy overly vague, and it is nearly impossible to find a remedy that is fair to either side in the dispute. Plus, the growing use of AI-generated channels that openly repurpose content from all creators without attribution should strike fear in both sides, as AI channels are almost impossible to fight, often generating 10 or even hundreds of times the views of the original content, and keep the profit for themselves. Huneault has vowed that he will never settle this case, and is looking for a definitive victory over Cordova, while Cordova, through Newman, is more amenable towards resolution. This was, again, the first skirmish in a greater war. This is an ongoing news story.